When the new bill was presented for comment during the legislative process, it was open to much scrutiny.
The bill remains fundamentally flawed because it doesn't deliver an equitable electoral system. It's not an electoral system that's going to enhance accountability. It's not an electoral system that's going to give a meaningful role for independent candidates to play in our politics going forward. But that does not necessarily mean that the bill will be declared unconstitutional.
On the 17th of April 2023, President Cyril Ramaphosa signed the bill into law. Now, just months ahead of 2024, the constitutionality of the Act will be tested. Despite the significant milestone, the first applicant, the Independent Candidate Association of South Africa, contends that the amendments do not level the playing field, as an independent must get more votes than a political party to gain a seat in the National Assembly. The organization will argue on several grounds that this is inconsistent with the Constitution.
When they do the seat allocations, as we know, there's 400 members of National Parliament. So what has happened is when they do the seat allocations, what we call the quota, in the past and currently, political parties to qualify only need 43,000 votes to get a seat in Parliament. The bill is written, and now the Act is written, so that for independent candidates to qualify, because it's now regions, will have to get between 77,000 votes and 93,000 votes, nearly double that of political parties.
The One SA movement will make similar submissions that the Act places impermissible and arbitrary barriers to entry for independents by placing unreasonably high signature requirements on them. The organization will also argue that the Act will result in an unfair and unequal advantage for larger political parties and a disproportionate disadvantage for independents. Meanwhile, the Rivonia Circle has been admitted as a friend of the court in the matter to assist the court in making a determination. Their submissions will center on the signature requirement.
The signature requirement on unrepresented political parties and independent candidates has potential to harm our constitutional democracy and our multi-party democracy. It also introduces uneven and unequal treatment between represented parties, those parties already in the National Assembly or in provincial legislatures, and those parties who are not in those houses.
The matter is expected to proceed on Tuesday at 10 a.m. Kani Mapanga, SABC News, Johannesburg.